When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of ultra-virus acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful.
No matter how minute
of this right, no matter how minute.
Who comes to equity must come with clean hands. Hello out there, you're welcome to another fresh episode of the program Justify Nigeria on ACNN television. On today's episode, we are going to be looking at the topic that says the legal concept of parties. My name is Anozechi Nomso, your anchor. For any lawsuit in the world, there must be parties to the suit. In both criminal and civil proceedings, the presence of parties must be made manifest. Parties, simply put, are the principal people in a lawsuit. In a civil suit, for example, the person who files the suit is called the plaintiff, and the person being sued is called the defendant. In a criminal proceeding, one party is the government called the state, and the other party is called the defendant. But in a situation where the parties are not present in court, what then will be the fate of the lawsuits? What will be the reaction of the courts when parties are absent in court? What are the types of parties and nomenclature they go with? Can the court dispense with the physical presence of the parties in a lawsuit? With me in the studio to address all this is Barrister Richard Ebie. Barrister Richard Ebie is a graduate of Nnamdi Azikiwe University, Anambra State, senior counsel and principal partner of E.M. Richard & Co. here in Abuja. He's also a member of Unity Barr, Abuja. You are welcome to the program.
Thank you very much, my brother.
Now, we are talking about parties. Now, there are some of our viewers out there that might not know what parties is all about. The essence of Justify Nigeria is to educate people on the finer points of governance through legal system and also to educate them. So based on that perspective, what is party or who can be called parties in a lawsuit?
Well, before I go to parties in a lawsuit, I'd like to define parties generally. Okay. Now, party or a party is a person or group of persons that constitutes a single side or a particular side in a dispute or in a context. This is the general definition of parties. Now, in any kind of dispute or any kind of contest, maybe electoral context or a contest over property or the arguments between two friends or two individuals or two groups of people, there is always one side. Okay. And there is also the other side. Like there are two sides of a coin. Okay. So one side of the coin is one party and the other side of the coin is another party. So that is parties generally. Okay. Now coming to a lawsuit. Okay. A party.
Okay, what you just gave is the general, both a layman and all that.
Exactly.
That's what party is all about. Exactly. Then coming to a lawsuit. Okay,
coming to a lawsuit. Now, when you have a lawsuit, the parties to the lawsuit, by the definition of the parties in the grain by Justice Toby, it says that the parties are those persons whose names are designated as parties.
Okay, you just quoted an authority now.
Yes, either as a defendant or as a plaintiff.
Okay, now you are saying that there must be at least two sides.
Two sides.
Yes, and those people now are the people that constitute the parties in a lawsuit.
Yes.
And you just quoted an authority of green against green.
Yes.
And there was an honorable justice who made that dig to that statement there.
Exactly.
So that's what it means.
Yes.
Now, sir, now having told us what parties are all about, are there types of parties? If they are, can you just name them and also explain it, not just professionally, but to layman view how they will understand it? First of all, there are types of parties.
There are types of parties. The types of parties are categorized according to the degree of interest that they have in the litigation. Okay. Now, in the first place, you have what they call the proper parties. Okay. Proper parties are persons that, for good reasons, they are made a party to that suit. For instance, they may not have an interest in the claim of the plaintiff, or they may not have a common interest with the plaintiff, but they must be made a party to that.
Can you use a scenario, because you are saying that they might not necessarily be plaintiff and defendant?
No, they might not necessarily be plaintiff.
Okay.
If they are not plaintiff, then of course they must be defendant.
Okay.
There are two sides to litigation.
Okay, there must be two sides to litigation.
Yes.
So if they are not plaintiff,
if they are not plaintiff,
they might be defendant.
They must be defendant.
And they are called proper parties.
They are called proper parties. In other words, without them, the action cannot be properly constituted.
Okay.
For instance, you want to take an action to rescind a contract. You want to take an action to rescind a contract, you must make the parties to that contract parties to that lawsuit. Okay. You cannot bring a lawsuit to rescind a contract, without making the parties to that contract parties to the action.
Okay, so people that constituted that contract,
yes,
they must be proper parties.
They must be proper parties.
Even if they are 100, they must be proper parties.
They must be proper parties. So without them, in fact, the action cannot be said to be properly constituted.
Okay.
So another type is what the Supreme Court in Green and Green designated as desirable parties.
Desirable party. So one is proper party,
yes.
Number one is desirable party.
Another one is desirable.
Okay.
They are desirable because they have an interest in the subject matter of the suit, and they are people that also might be affected by the outcome of the action. So they are desirable to be made a party, although not all of them might be made a party. You understand? Okay. So desirable parties, yes, they are desired to be parties, but the absence of one or two of them may not affect the jurisdiction of the court. Okay. Then you have necessary parties.
Okay, that's the third one now, necessary parties. Okay.
Necessary parties are the parties that their presence is vital, very necessary to the determination of the issues before the court. The absence of the necessary party can affect the jurisdiction of the court. In other words, their presence is needed for the complete adjudication of the court on all the issues raised in the subject matter of the suit. Because if they are not made a party to that action, and the issues raised, probably part of the issues relating to them, are not resolved or are resolved in their absence, they too might even also raise another lawsuit to determine the issues as relating to them. And that is why they are necessary for the determination of all the issues relating to the subject matter of that.
Just like the name lawsuit applies, necessary
parties.
Okay.
And then you also have nominal parties.
Nominal, okay.
Nominal parties. This nominal, just as the name implies, is just a party in name, just in name only.
Okay.
He may not be involved in the cause of action. He may not even be the person that committed the wrongful act that gave rise to the cause of action in the case. But he's made a party anyway, maybe by virtue of the office that he occupies, or by virtue of the connection that he has with the parties in the case.
Maybe, for example, when you talk about Office of Accountant General,
Accountant
Office of
General, the most relevant example is Attorney General of the Federation. You know, the office, the constitution that created the Office of the Attorney General of the Federation gives the Attorney General of the Federation a lot of powers and a lot of responsibilities and duties. And even to the extent that any action against the federal government whom he represents or against any agency of the federal government, he is a nominal party. He must be, he can be made a party to that case as a nominal party. It doesn't have to be maybe as a result of his wrongful act. No, it's just by name. In fact, in the case of AG Kano State and AG Federation, and another case of Ezomo and AG Bender, the court said the Attorney General in that case was raising issues of, oh, you can't make me a party to this suit because I was not involved in the wrongful act that gave rise to the cause of action. But the court said no.
That your office,
any action against, once somebody has a complaint against the federal government or
the state,
any agency of the federal government, you are at least a nominal party, even if you have committed no wrong. So that's the...
Thank you very much. Thank you so much. In fact, this is becoming more interesting, but you will continue after we come back from break. Please, viewers, do join us again. Hi, you are welcome to the speaker on ACNN television reaching you from Abuja. On today's edition, we'll be looking at the phrase or the statement that says a constitutional Nigeria or an unconstitutional Nigeria. My name is Anazechi Nomso. A constitution in this context is an aggregate, compendium and embodiment of laws enshrined and contained in a document which spells out the fundamental principle of governance towards the people and the behavioral pattern of people towards the government. This means that in a constitutional state, it is expected that all men, including the leaders and the led, must conform themselves with the provisions of the law. In fact, I dare say, there are no sacred cows when it comes to the strict adherence of the law, because the law is a respecter of no person. From this premise, it is both factually and logically true that the breakdown of law and order, chaos and humanization, intimidation and oppression can only be found in an unconstitutional state. With the kind of lawless state of Nigeria, I'm persuaded to ask on whether we are living in a constitutional Nigeria or an unconstitutional Nigeria. In a situation where the political class do not obey court orders is an example of an unconstitutional Nigeria. In a situation where unknown gunmen attack police stations across the states of Nigeria and break up correctional service centers formerly known as Nigerian Prison Service is a clearer picture of an unconstitutional Nigeria. Consider a situation where up till now, killer henchmen and Boko Haram have not been publicly declared terrorist group by the federal government, and yet IPOB, who are armless, are declared a terrorist group. Is that not a clearer fact of unconstitutional Nigeria? Your answer is as good as mine. What about the situation where the federal government dispensed with the procedure of the Federal Character Commission with impunity in governmental and political appointments, whereby only one sect of religion, tribe, and ethnicity is favored more than the rest of another Nigeria? Is that not a perfect example of unconstitutional Nigeria? Another jam question for you. How can it be that Naira has depreciated to 480 Naira per dollar? How can it be that up till now, some of the Chibok girls are still in the custody of Boko Haram? How can it be that the chairman of Code of Conduct Tribunal, CCT, in the person of Danladi Umar, allegedly and physically assaulted a security personnel at Banex Plaza, Wuse to Abuja, because the security man who was on his duty post directed Danladi Umar on the right way to park his car? How can it be that the level of oppression, intimidation, and man's inhumanity to fellow man is increasing in geometric progression in Nigeria on a daily basis? If a chairman of Code of Conduct Tribunal, who should uphold justice at all costs and always put on his garment of humility, ironically and adversely tend to become a symbol of pride, arrogance, and shame, what then is expected of ordinary citizen? How can it be that reports coming from Defense Intelligence Agency, DIA, reveals that 400 businessmen have been funding Boko Haram insurgents and bandits? All these can only happen in an unconstitutional Nigeria. In order to justify Nigeria, I therefore speak, until the government wake up and face squarely their responsibility in providing adequate and maximum protection of lives and properties, begin to prosecute these offenders of the law, no matter whose ox is God, condemn bad things at all times, and stop deceiving Nigerians with high level of grammar in order to cover up their evil deed, and do all they can to ensure that Nigeria becomes a place where peace and justice shall reign. We shall continue to have unconstitutional Nigeria instead of a constitutional Nigeria. My name is Anozechi Nomso. I just want to speak. Hello viewers, glad to know that you are still there, and we are still here with Barrister Richard Ebie. Barrister, thank you for still remaining with us.
Thank you very much.
Before we went for break, you have given us what party is all about, generally,
yes,
and in the context of the law. And you have done so much well in telling us types of parties, talking about that of a nominal party, necessary party, and other ones. Now, what I want us to find out, apart from necessary party, because you made mention, Barrister, that necessary party, the people must be physically present.
Yeah.
Now, in other ones, must their presence be needed in courts in order to determine the proper adjudication of the matter?
There are not all the parties whose presence cannot be dispensed with. As a matter of fact, most of the authorities are very unanimous in saying that once there are no proper parties before the court, then the action is not properly constituted. But it is not the absence of all the parties that can affect the competence of the action. Okay. Now, the law has always leaned in favor of preserving the subject matter of the suit and deciding issues between the parties actually before the court. So generally, the law is that a joinder or non-joinder or misjoinder of a party does not affect the competence of the action. In other words, it is not all the parties that are desirable, for instance. Not all the parties that are desirable to be parties in that action that must be a party to that action for that action to be competent.
Now, Counsel, you've done well in explaining certain types of parties. Now, the question I'm asking, now, in parties to a suit, must all of them be physically present? For example, there are some suits you will get, maybe this statement of claim now, Mr. A, plaintiff, Mr. B, defendant, and 8 others.
Yes.
Now, those 8 others, must they be in court for proper adjudication of the matter?
Yeah. Now, the consequence of the absence of any of the parties would depend on the nature of the proceedings, whether it is a criminal proceedings or a civil proceedings.
Okay.
So let me start with the civil proceedings.
Okay.
In a civil proceedings, there is the plaintiff, there is the defendant.
Okay.
If they are two single individuals. Now, the absence of the plaintiff.
The plaintiff is the person that brought the matter to court.
The plaintiff is the person that brought the matter to court.
Court.
Yes, that instituted the action in court.
Good.
Now, when the plaintiff who brought the action, who instituted the action in court, is not in court to prosecute his own matter, then the court can likely strike out the case for want of diligent prosecution.
Okay.
Yes. Although some court will, out of excess of caution, ex abundantia cautela.
Please explain that. We are not all of us are lawyers. It's a ex abundantia cautela. What does it mean, sir?
That is out of abundance of caution.
Okay.
Out of abundance of caution.
Okay.
Then the court might desire to give a plaintiff who is absent in court, give him another opportunity by adjourning the matter.
Okay.
So that on the next adjourned date, if there was any genuine reason why he was not in court on this particular day, then he might be in court on the next adjourned date to resume the prosecution of his matter.
But what happens in that next adjourned date? He fails to appear.
If he fails to appear, then the court may have no option but to strike out.
So the ex abundantia non cartel will not apply on this case. Okay. All right.
So
okay.
The court will strike out the matter for want of diligent prosecution. And then that is also subject to the right of the plaintiff to release the matter, because the matter struck out is not decided on the merit, and it's still the matter still remains undecided and can still be relisted on the application of the plaintiff.
Okay.
Now,
striking out a matter is not the actual determination of the matter.
It's not the end of the story.
It's not the end of the story. It's not dismissal.
It's not a dismissal. It does not amount to dismissal. Even if the court used the word dismissal, it does not amount to dismissal. In the circumstance, the court will deem that it is deemed as a striking out order, even if the court said the case is hereby dismissed. Okay. So when a plaintiff is absent in court and the court strikes out the case for want of diligent prosecution, the matter can still be released.
Okay.
Because the matter is not it's not. The case has not been fully determined.
Okay.
Then on the part of the defendant, where the defendant is not in court, two things can happen depending on the nature of the claim before the court. If it is a matter that where the court can give a summary judgment, like in an undefended list proceedings, the court can just go ahead and give judgment.
Okay, even without the physical presence of the defendant?
Without the presence of the defendant.
Okay.
But in doing that, the court has to satisfy itself that the defendant was put on notice of the proceedings.
Okay.
In other words, that the defendant was served any notice, was fully aware of the date and place of the proceedings, but choose not to come to court, and then the court can decide.
Before we round up, we have a few minutes now. That of the criminal, can you just divert to that of the criminal?
Now, that of the criminal, if the prosecutor or the complainant is not in court, the court can also, in its discretion, strike out the case for want of diligent prosecution.
The same thing that applies to the civil.
The civil.
Okay.
And the court, although it also lies in the discretion of the court to give another opportunity for the prosecution to appear in court to prove his case. Okay. And again, if it is struck out, not released, the case can be referred by the prosecutor or by the complainant. And then as for the defendant, this is where the court cannot just give judgment against the defendant in the absence of the defendant in the criminal matter.
Unlike the civil matter.
Unlike the civil matter.
Okay.
The court has to issue what we call bench warrant engage the defendant. In other words, it is an authority to the police to arrest the defendant and bring him before the court, because he has to be present to witness the proceedings and the judgment against him.
It means it's a necessary party.
Yes. Yes.
Now I understood what you are saying.
But
yes,
there are some exceptions anyway. There are a few occasions where the court can dispense with the
physical presence.
the physical presence of the defendant.
For example,
As provided in the recent Administration of Criminal Justice Act 2015, Section 135 of the Act. Now, in that, there are exceptions there. If the offense is punishable with fine,
okay,
not more than 10,000 naira,
okay,
or with imprisonment of not more than 6 months, and the defendant pleads guilty in writing. That is, without coming to court, he can plead guilty in writing and send it to the court. Oh, I'm guilty of this offense. The court can dispense with his presence if they don't need him to be here. And the court can go ahead and convict him in his absence.
Okay.
And then another exception is where the defendant misbehaves before the court, misconducts himself in court, to the extent that he becomes an impediment to the hearing of the case. The court can dispense with his presence.
Okay.
And then again, another one is still another exception pursuant to Section 266 of the Administration of Criminal Justice Act 2015, is where the only business of the day is for hearing of interlocutory application.
In fact,
for instance, hearing of bail.
We are going to bring you back because we're out of time. You're going to come back next time because it's becoming more interesting.
Thank you.
We want to appreciate you for coming.
Thank you.
And when next we bring you, are going to tell us even the nomenclature, because I discovered that as at the time you're talking about the civil, you are talking about claimant and plaintiff and defender, but in this way you talk about prosecution.
Yeah.
These and more you explain to us in next time we're going to invite you. Meanwhile, I want to appreciate you for coming. Thank you so much.
The pleasure is mine.
Thank you. Parties are very important in a lawsuit, be it civil or criminal matter. As long as matters in court is concerned, there must be at least 2 parties to that suit. It is therefore needful that the parties concerned must be in court for an effective deliberation and adjudication of the matter. However, there are certain situations and circumstances when the court will dispense with the physical presence of parties and proceed in giving a ruling or issuing an order. Remember, justice must not only be seen to be done, but also objectively seen to be manifestly done. It is therefore advised that parties to a lawsuit must assist the courts to administer justice both judiciously and judicially by being present in court anytime such matters are being called upon in courts. Viewers, this is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station on another fresh episode of the program. Until then, my name is Anoze Chinomso. Urging you bye for now. When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.